P16052-620DK. The swab from the Ruger 40 caliber pistol was isolated and retained as P16052-634DK. The swab from the Ruger 357 revolver was isolated as 1605264DK. Number 7, in April of 2017, David Canaris tested the following items which were seized from the Almenninger residence: a rectangular rug P1605434A, an oval rug P1605435O, a rectangular rug P160543551, a spray bottle of glass cleaner P160543553, a spray bottle of 409 cleaner P160543556, a bleach container P160543667. All these items tested chemically negative for blood. And then turning to the last set of stipulations I haven't read yet, these pertain to Stacy Johnson, so the jury probably recalls that her section started as follows. The parties agree and stipulate that, if called as a witness, Stacy Johnson would testify to the following, and therefore the parties stipulate to the following facts. I'm going to start with number 6 because I previously read 1 through 5. In 2018, Stacy Johnson also analyzed the contact DNA swab from the Springfield 9mm caliber pistol P16052-620DK and the contact DNA swab from the Ruger 40 caliber pistol P16052-634DK obtained by forensic scientist David Canaris in 2016 and found male DNA in each sample, but the quantities were insufficient for any further analysis. Number 7, in 2019, Stacy Johnson analyzed, let me start over again. Number 7, in 2019, Stacy Johnson analyzed the Ruger 40 caliber pistol P16052-634 by removing the grips and examining the grips and frame of the pistol. Testing of the stain she isolated from the lower edge of the right grip of the pistol P16052-634-1 revealed that a major component of the stain matched the DNA profile from David Grunwald. Stacy Johnson also isolated a stain from the hole in the base of the Ruger magazine P19004299-1, and testing revealed that the major component of the stain matched the DNA profile from David Grunwald. Stacy Johnson did not locate any stains on the Springfield 9mm magazine P19004300. Number 8, in 2019, Stacy Johnson tested the swab of a stain from the driver's seat of a Dodge Neon from the Peterson property. The major component of this sample matched the DNA profile from Devin Peterson and did not match the DNA profile from David Grunwald.
And just for the record, what do the P numbers stand for, so the jury understands that?
Those are the numbers that the troopers attach the property numbers to the items, but then if the lab pulls off swabs or stains, they use the same numbers, but then add another number, either another number or letter at the end.
Okay, all right. Okay, does the state have any other witnesses to present?
We do not have any other witnesses. We rest at this point.
Okay, so members of the jury, the state's case is finished. We'll take a brief recess and we'll go forward with the defense's case, okay? All right, go ahead, sir.
I just want to make sure I have the counts in order, because I have two, I think, two different sets of instructions. So, Your Honor, on behalf of Mr. Renfro, we're moving for judgment of acquittal on some or all of the counts here at the time the state has rested. And if there are counts left over, the court denies the motion, we will renew it once the defense rests. I don't know if the court is used to this procedure before the defense case or not, but he has a right under the Fifth Amendment to request this, make this motion when the state ends without having to take the stand, and then, bring the motion on. So depending upon what the court decides. I'm not going to go into a long legal argument, Your Honor. I think you know this case very well for a lot of reasons, and you know what the facts are, and you've heard the testimony before and this last month in this case. I think the issue is pretty simple, and that is, as far as the murder counts, count 1, 3, 4, and count 2, the assault, count 5, the kidnapping. Let's start with those. Those 5 counts involve the beating, transportation, and then the shooting of David Grunwald. And our argument is that as far as being the principle or evidence that he actually engaged in assaulting David, that he willingly was on board for this kidnapping aspect, the intermediate phase, nor the actual shooting itself. This case, this is the case the state has brought and has stuck with its theory that they can't prove who the shooter is, so everybody will be tried as accomplices. So the real issue is, given the lack of physical evidence or other circumstantial evidence of that nature, that Bradley was a principal to the assault, kidnapping, or murder, this is going to come down to an analysis of accomplice liability. And under that statute, in this case, we have tried this case on the basis that really the sole element in question is Bradley's subjective state of mind. And once again, the evidence of those 5 or 6 concerning facts that Trooper Wegston cited at the end of the state's direct examination of him, starting with Bradley helping David up, or, well, they didn't know what happened in the trailer. There's no testimony about that in detail, but helped him to the Bronco, and that he made statements in the Bronco about locations that they might go to. You know, he's in the back seat, he's not driving the car, but there was some discussion of where they were going. He didn't know where they were going until they started talking about it and suggested those locations. As far as those counts, that's really about all there is. No evidence that he was involved in the planning and ahead of time. No evidence that he intended in any way. He didn't know what the circumstances were. He just knew he was a couple hours earlier, an hour earlier, he was escorting Dominic Johnson and Austin Barrett from the shack he was residing in because they didn't know how to get to Eric's house. His intention, and that exhibit has been entered into evidence, and I think the sergeant, after a little bit of discussion about it, agreed that it appeared as though rather than that question being, well, he could have spent the night anywhere or Allmendinger's. In the context of the full communication, it's pretty clear he was at the shack at Alyssa Bledsoe's residence. But for them needing directions, because they'd never done that walk through the woods and it was dark, he would have just been at his temporary housing for the night and wouldn't have even been there at all. So even without him testifying to tell in detail his story, there's a lack of proof in all regards, including his state of mind, his subjective state of mind, beyond a reasonable doubt. As to the remaining counts, where the other couple of major concerns of law enforcement or bad facts was when the discussion about what to do with the vehicle came up, and one of the co-defendants talked about we got to burn it. That is when Bradley Renfro said, I know where we can get a gas can at Devin's house. And then after getting that gas can, he's seen on a video filling the gas can up and eventually admitting that he participated in torching the Bronco, the arson count, which would be count count 9. And as far as count 6 about suppressing evidence or concealing or destroying or altering, he also admitted that he was at the camper or the trailer on Allmendinger's property when they took that cab ride and ran out of money, and they walked whatever distance they walked to the trailer. There's no reference that or testimony that he was actually in the trailer and engaging in the physical cleanup, but he was present standing outside the trailer. And then I suppose as an accomplice, the vehicle theft wasn't singled out, but falls under the, could arguably fall under the arson count as well, nonetheless. So the bad acts, going to the trail, being involved with actually torching the Bronco, being involved with, at least present when the trailer was cleaned, continued associations in and of themselves, of course, are not illegal, but they do bear on his subjective state of mind, one way or another. And his interviews can be viewed as problematic in either deceiving or hiding or failing to disclose all that would happen if he, or not talk at all, but nonetheless, that could, that's also would be something I would think a trier of fact would take under consideration when looking at his subjective state of mind. Now, there's been cross-examination regarding a different context to all of those actions. And if a trier of fact was, by preponderance of the evidence, convinced that he was genuinely shocked and afraid that if he did not appear to be not cooperating with them or just going along with it and avoiding disclosing what happened or reporting it in any manner, and we can speculate, you know, we could have made an anonymous tip at some other point, but again, there's the significance of analyzing Bradley's state of mind from a adolescent perspective at that time after experiencing that horrific chain of events, and at his age, whether or not it was reasonable for him to be afraid to disengage or to intervene or to object or to report what happened out of fear that, having seen what they are capable of doing, consumed him with fear, really, frankly. So, is there enough evidence regarding his subjective state of mind to cast sufficient doubt that that element has not been proven by a reasonable doubt? Then all counts should be acquitted on all counts. But if the court essentially, as in this type of motion, finds that the state didn't prove the murder, kidnapping, and assault on David, that there's such a arguably small amount that could be, in the eyes of a trier of fact, that there was some degree of mens rea, that some awareness that, well, that frankly, what I'm saying, Your Honor, is the evidence is far too deficient for the higher end counts to find beyond a reasonable doubt that Bradley was an accomplice to the murder, kidnapping, and the assault. But given his active role subsequently, I would still maintain that his actions were consistent with maintaining an appearance of keeping this, not letting on that, not letting on to the co-defendants that he was not on board with this at all. But given those active, more active involvement as far as actual circumstantial evidence and not just the subjective argument, we understand that a trier of fact might find beyond a reasonable doubt that he had whether it was a cooling off period and then he just gave up with the idea of ever reporting, or whatever it was. I could see that a trier of fact may go along with finding him guilty of those post-homicide counts that are also charged. And that's the essence of our argument.
Okay. Do you want to respond at this time, Mr. Kalachuk?
Judge, part of the problem with the defense argument is that defense counsel is relying on his client's statement in that December 6th interview as being true and accurate. Now, the cases that talk about motion for acquittal, judgment of acquittal, talk about reasonable jurors. I am confident that this jury is not going to buy that December 6th story hook, line, and sinker. There are too many other things that point to the fact that even that last story he gave was untruthful. I'm confident that because we have jurors with a wide range of experience, that they will do what the state is going to ask them to do in that looking at what happened before this 3-hour period and what happened after this 3-hour period. All the events that are the subject of the criminal charges happened roughly in a 3-hour time period. Now, this jury is going to see, as to the defendant's contention, that he is just a poor guy that was stuck there and scared of his buddies, when there was no indication of that beforehand in any of his interviews or his behavior. The jury's going to have to look at the fact that they're getting high in the shed and laughing and joking before the murder. They're going to have to look at the video afterwards, where they are again getting high, getting drunk, peeing on themselves, grabbing each other. I am confident that the jury will look at those things because they have to look at all the facts and circumstances as to this issue of whether he was a voluntary participant. And some of the jurors, we put one juror off. We let go a juror because his opinion was this is likely an all or nothing. This likely is an all or nothing because we have an issue of whether he was a voluntary participant or not. And as to the arson, of course the defense is going to make a less strenuous argument for judgment of acquittal on the C felonies. Frankly, there's not much exposure on those things for a defendant, and he's on videotape, and he confessed to getting the gas cans and buying the gas at the end. So I didn't expect there to be much of a fight on that issue. But as to the main issue, was he at the crime scene? Its bottom line is the jury has to consider all his lies. And that's a sub-issue. Did he lie because he was truly scared? Or did he lie because of allegiances and involvement in the crimes here? I think the second argument is much more plausible, given a few other things, given the behavior beforehand and after, and given the fact that he was adamant in his first 2 interviews that he was not afraid of his buddies. And he continued to go to Thanksgiving dinner with them, go to parties with them, hang out with them, which I think the jury's going to take into consideration. Now, as far as his admissions, he admits being at all 4 crime scenes, and I call them 4 crime scenes because I'm referring to the camper as number 1, the Bronco is number 2, the Knik River Road is number 3, and the trail that goes up to Baldy as number 4. He admits it being at all the crime scenes. Now, we have, according to the jury instructions, so many different ways of proving accomplice liability. He could be involved in the planning. He can give encouragement. He can provide incitement. He can counsel as to how the crime is to be committed. The law gives us many options on how to prove that somebody was an aider and abetter. And as far as his quote-unquote admissions, the few pieces in his interviews that were close to the truth, he does admit that he participated in discussions about where the murder should occur. He even gave suggestions as to where he thought the murder should occur. Again, okay, he didn't say that he suggested Baldy for the burning of the Bronco, but he suggested Little Sioux because he had camped there. And that the jury has that in both the transcript and the tapes that were played to them. So he is actively participating in decisions about where David Grunwald should be killed shortly after he is pistol whipped. The pistol whipping, the medical examiner, I know it's been a long time, but there were numerous injuries to David Grunwald. I think there was 7 to the head alone, but there are numerous injuries, as the court remembers, on his defensive wounds. It is unlikely that one person caused the pistol whipping, and the nature of the camper trailer is going to become an issue as to whether everybody knew it was going on and whether it was a group effort. Perhaps one of the more important pieces of evidence is the fact that eventually in the December 6th interview, he acknowledged that there was discussion about killing David Grunwald and knowledge on his part that David Grunwald would be killed even before Eric Almendinger went inside the house to get the gun. So that puts the discussions before David Grunwald was beaten by the pistol, by the use of the pistol. But again, the lies are going to be important here because obviously when we go to the closing arguments, there's going to be 2 vastly differing opinions on the part of the state and the defense as to his participation in this case. Obviously, the teenage brain expert was brought in, I think, to a degree for sympathy, but we know where the closing arguments are going here. The state's going to argue they were all buddies. They all thought they were in a gang. They created this fire. As Christian Ward put it, he studied the behavior of this group. He was there and studied Almendinger. His bottom line was they took it too far and it got dangerous. So, you know, the defendant is trying to say that the fire he stoked with his buddies, eventually he was afraid of that fire. And the state's confident, and we talk about reasonable jurors, the state's confident that they're going to see through that defense. But as to, you know, the obvious things, now we know that all of us know, Judge, that motion for judgment of acquittal is a very high standard for the defense. The cases have been around forever, and the standard is motion for judgment of acquittal should be granted only if fair-minded men and women, I should add in there, in the exercise of reasonable judgment could differ on the question of whether guilt had been established by the evidence beyond a reasonable doubt. And then also the most important thing, and that is, like, how should the court view the arguments and the evidence on this motion for acquittal? And that's the Gray case and other cases after it. In passing on motions for judgment of acquittal, the trial judge must view the evidence, not could, but must view the evidence, and not just the evidence, any reasonable inferences therefrom in the light most favorable to the state, and must deny the motion if reasonable men could differ on the question of whether guilt has been established beyond a reasonable doubt. There are some newer cases. There is one case that came to my attention. It's an unpublished opinion, but it was a 2012 case. I have one copy, but I could show counsel eventually and show the court. It's Egby versus State. This is appeals number A-10356. And it had a similar issue. One of the issues in there was similar. On appeal, Egby contended that the evidence in his trial was insufficient for him to be convicted as an aider and abettor. And it goes a bit to the arguments before the court today, in that the court did go through the facts and Egby's conduct and to determine whether the conviction was justified. And in that particular case, it was different than this one, obviously, but it was in August, Egby and another person, Charles Egby and Marquise Hiriams, and an unidentified man basically robbed the China King restaurant on East Fireweed Lane in Anchorage. It was closing time. The owner was closing up. He emptied the tills. There were some coins still on the register. Then these 3 guys show up, but Hiriams was the one that pulled out the gun, grabbed the victim by the shirt, pulled him out of the building, and then the other unidentified man pushed Mr. Lin, the victim, against the building while Hiriams continued to threaten Lin with the gun. The only thing Egby did during this time period was hold the outside door open. I mean, literally, the only thing he did. That's what the Court of Appeals wrote during this time. Egby was holding the outside door open. So on appeal, there weren't too many points on appeal, but some of it was a sentencing issue, but and whether there was a mitigator. But Egby, one of the challenges was that there was insufficient evidence to support the conviction. And then again, they reiterated similar challenge after a verdict, that they say when we review a claim that the evidence was insufficient to support a conviction, we must uphold the jury's verdict unless the defendant can show that no reasonable jury could conclude the defendant is guilty beyond a reasonable doubt. So slightly different, but the review is the same. We review the evidence and inferences from the evidence in the light most favorable to upholding the jury's verdict. In this case, it says Egby assisted the robbery by holding the restaurant door open. This evidence, when viewed in the light most favorable to upholding the jury's verdict, is sufficient for a reasonable jury to conclude that Egby intentionally aided or abetted Hiriams and the unidentified man in planning or carrying out the robbery. So when Mr. Provost was making his argument, like that there wasn't a lot of evidence in this case, every one of these defendants' cases is going to be a little bit different, but the same arguments could be made and were made in Elmeninger's trial and in Johnson's trial. Elmeninger made a similar statement that Renfro did. He says he was there, but he didn't do it, and he named two different shooters, not himself. The only other things we had in Elmeninger, as the court recalls, was we had the text about the gun between him and Johnson, and then he did he did create a lot of the evidence that we used against him by taking a lot of photographs with guns and him in gang poses and gang attire and such, but that's basically what we had in Elmeninger. In Johnson, he didn't make any statements. So we didn't have any admissions by him that he was at any of the four crime scenes, but there were inferences drawn by that reasonable jury that because he took Sergeant Wegson to David's body, he had to have been there when the murder occurred. And then we had the text, obviously, between him and Elmeninger. That's going to be consistent throughout. But there were no admissions by him. Then we did discover the video during that trial, but obviously defense counsel pointed out that in those few seconds, it wasn't obvious that he was talking about David Grunwald when he was talking about hitting somebody in the head as hard as...
That's a misstatement of the court's ruling on that. That wasn't my objection. My objection was identifying the voices in the background. And the court allowed that video in for one single purpose, and that was to show that Dominic Johnson, there's certainly enough of a nexus there, timing-wise and location, that was relevant and highly relevant to the case. Otherwise, that was the only fact that the jury was to take away, the identity of Dominic Johnson, what he was saying, and where it sat in the short time period, both location at the shed and within a couple of 3 hours, David disappeared. So that was a misstatement, I believe, of both the facts and why the court allowed that video.
Actually, I'm talking about the Johnson trial. I'm comparing the quantum of evidence in the Johnson trial and the Elmeninger trial, both of which the court let go to the jury as compared to this case. I really wasn't commenting on the video as it was used in this particular case. I was commenting on the level of evidence that we had in the Johnson case as compared to the issues before the court today. So, in this particular case, Judge, I think the state has a very logical argument, and this is where human nature comes into play. I was involved in picking this jury. I could have challenged some of the ones that sat here. I'm confident they're going to have a reasonable view of this case. I'm confident they're going to rely on their personal experience and their reason, logic, and common sense. And I'm confident that Mr. Provost is going to have a hard time convincing him that the defendant was a scared, unwilling participant, giving his conduct before the murder and after the murder.
co-counsel a question before I do?
Sure.
All right, yeah, I recall it. So, Your Honor, Mr. Renfro has filed a notice, as the court is aware, of the affirmative defense of duress. And his burden to prove duress for that affirmative defense to apply.
And this is to which charge? I don't think it's available to murder in the first degree. Is that right?
What? Yeah, I was just looking at the case law this morning. Certainly murder too, and that is older case law, and
I
frankly,
just was just looking at the jury instructions, and I didn't see anything.
actually, I didn't. You know, in the packet, the draft packet we got, I was looking for. I didn't get the duress.
No, I didn't give it out, but I have basically affirmative
okay.
defense to second degree murder right in front of me. So.
Right.
But I didn't see one in the packet for first degree murder, so I don't think it's available. But anyway, you know, that'll be an issue we'll talk about, so.
So that affirmative defense would apply, his burden to prove by a preponderance that his actions after the fact were under duress. There are a few of these facts represented here that I would like to point out that without even hearing Bradley's story, there's enough in the cross-examination of the witnesses to put an entirely, frankly, more plausible explanation for his acts. So, starting with the statement on 12-6, and that may require the court to actually read the transcript or listen to that statement went down. That's when Trooper Dunford and Trooper Wegson were interrogating Bradley and almost talking over each other and putting the statement into Bradley's mouth, basically, asserting that he was aware or knew that Allmendinger was bringing the pistol to the trailer. And, isn't that right? I recall there was some silence, and then Trooper Dunford saying, so you agree, or something to that effect. I don't recall hearing him actually acknowledge that. In fact, it is, would be incredible that that is the only reference these troopers in interrogation putting in his mouth that he was aware that Allmendinger was bringing a gun to the trailer. There's no other evidence by any other witnesses that that's true. If his response was anything but a shaking of the head, or even if he went along with it, this is why the adolescent brain at his age at the time is important. The comments that the U.S. Supreme Court, and specifically addressing these kinds of incapacity to deal with the pressure of that kind of interrogation, and to either not be confused, not understand what was being asked, but the way it was asked, this happened, right? And I don't recall anything that we could hear. We couldn't see his face. So it's just the trooper saying that was the case, and I see that you agree with me. That fact is outrageous in the sense it's being used to put him in play before the assault even occurs. that alleged fact.
What page
Now-
is that on?
Oh, I did, Mr. Kalchek made the state, you know, made the assertion of fact in his opposition.
I don't
You
have
know
it in
what
front of
page
me.
that
It's the one where Trooper Dunford explains that, you know, that, and he verifies later with the statement, I see you're shaking, nodding your head or something like that. I don't remember exactly which page it's on, but, I mean, that's not the biggest disturbance we're going on.
Regarding these other facts leading up to the homicide, there's apparently the state's theory that by Bradley Renfro's action in assisting or helping David get to the car in his condition was aiding and abetting a kidnapping. This again goes back to that subjective analysis or a subjective assessment of his state of mind. He was consistent in all of his interviews despite not either lying or not telling the whole story to avoid being identified as somebody who was cooperating publicly, either through press or through the word of mouth that he had contact with troopers, out of fear that he would disappear too. That action to get in the vehicle, and I mean, David was having a hard time standing up, and in his state of mind at the time, just as shocked, traumatized by what he heard and could barely see, and then being ordered everybody in the car, and he helps David walk out. That is so typical of what a fight or flight response, complete takeover by the limbic system on a barely 16-year-old juvenile in those circumstances, when he didn't even know this was going to come down. As far as, again, lots of emphasis on statements about where to go with David. Where were they going to kill him? It's all speculation about what was really, what the timing of the plan for killing him was. But this much we know, at some point, everybody realized, including poor David himself, that this was gonna end bad. When they were talking about taking him to the Butte, he's saying, no, take him to Jim Creek. And we heard from Trooper Wegson that it is a very popular place year-round. More so in the summer, of course, but lots of winter activity. He is suggesting a place where they would either be deterred from, at the last minute, from taking them more remote, or maybe they just, instead of gunfire, drop them off up the road and, in his mind, perhaps hope that he will survive. Somebody will find him. Maybe he will stumble his way back into where people are. And that's the same thing about the Coal, was it Point or? Huh? Coal Hills up in Sutton. Trooper Wegson confirmed the assertion that both of those places were highly public places. Coal Hills, especially on the weekend. It's no coincidence that Bradley Renfro, as far as where to go with David, made those two suggestions after they started talking about a more remote, a more remote place to take David than those two. And that brings us back to what was his, so where is the proof beyond a reasonable doubt that he aided or abetted or planned or intended that what happened to David Grunwald, that burden was met? That, beyond a reasonable doubt. And the state is suggesting he should be convicted for murder for that much evidence? I won't repeat the rest of the counts because it's the same argument. Once David was killed, he was pretty much, man, I'm just gonna maintain a low profile and not let on that I am scared of you guys. Just like I told one of the troopers, I think it was the 1126, or no, it was maybe 1130, when confronted with hanging around with a group of killers. Well, I hope I'm not. I mean, he knew it then, you know, I hope I'm not hanging around with killers. He knew they were killers. There's another reason why he made that comment. I hope they don't kill me. Now, if you had no doubt that he was under duress, even if you don't use the standard, even if you take out the affirmative defense of duress, if you're convinced that it had nothing to do with it, that he was traumatized and shocked about what happened, that he couldn't bring himself to intervene, that he couldn't come to the place soon enough to report one way or another, talk to somebody, talk to a trustworthy adult, a lawyer.
Judge,
to-
are we doing closings right now? Because, I mean, this is like, we're all aware of the standard. We just established for the court that there are issues to go to the jury in this case. I am so looking forward to Mr. Provost trying to sell the notion to this jury that his client was trying to help David Grunwald. I'm really looking forward to that, to see how he's going to sell the jury on that. I mean, now we're getting into fantasy land.
So, Your Honor, just to wrap it up, sorry about my passion and my view of this case, but he did have active participation. Maybe there was enough time where he could have done something to help, identify where David was, tell everybody what happened. But even so, even if we throw that into the mix, does that rise to a level beyond a reasonable doubt?
That's the standard for a verdict, not for the motion for judgment of acquittal.
Well, as Mr. Kalichuk has raised, and as I was reading this morning, are you picking me up, okay? The Gray case states as follows: in passing on motions for the judgment of acquittal, a trial judge must view the evidence and any reasonable inferences therefrom in the light most favorable to the state, and must deny the motion if reasonable men could differ on the question of whether guilty has been established beyond a reasonable doubt. I will agree with the defense that regarding accomplice liability, the issue really is what is the intent. And did he have the intent to aid and abet? Did he have the intent to facilitate the beating, the killing of David Grunwald? How do we know that? How do we know what his intent is? Well, I read the jury instruction yesterday, and intent can seldom be proved except by circumstantial evidence. And what we do is we look at the factors and facts that have been presented in the case. In this case, we have facts regarding the relationship of the parties, before and after. we have the conduct of the defendant the night of the incident, and we have his statements. So the real question is I look at this in the light most favorable to the state and the inferences therefrom. And I think that's the key. Can I infer, if I look at this solely in the light most reasonable to the state, that he could have formed the intent to assist and aid and abet in all 4 or 5 of those crimes that night? And the answer is, with that high standard, is yes. I mean, he's placed at the scene, there's no doubt about that. He's placed in the car, he's placed in the trailer. I don't think that's being contested. What evidence do they have that he participated in the actual beating? Not much. But he's in the trailer, and then he has commentary that he makes in his statements of what's going on. And can you infer that he was aiding and abetting in that assault? I think reasonable jurors can differ on that, and that's going to be left for the jury to decide. I will also somewhat disagree with Mr. Kalachek. This case is different than the other two. The other two, we did have those emails between Mr. Almendinger and Mr. Johnson, which clearly formed the intent to do something to David Grunwald. I mean, that was 5 minutes before the incident. Bring me the gun. I need to do this now. Did Mr. Bradley, was he aware of that? The jury's going to have to decide that. You could, if you look at his statements, and you could infer that he had knowledge that that might occur. There was a lot of talk about, you know, at what point did he learn they were going to kill him, but by the time they got out to the Knik River, even by his own statements, I don't think there's a fact that he knew what was going to happen at that point. But, again, is that aiding and abetting? The jury will decide, because I have to look at this just basically believing the state's assertions and the inferences coming from that point of view. The other thing is the conduct before. They all went to the house together. I heard the video. I mean, it's obvious that the inference that could come from the video is that he was taking the video, and that's by his girlfriend. So there is an inference that he was in that shack beforehand and that he heard the intent that Dominic Johnson made. But again, that's an inference that can be argued from the other point of view. But that's not my position, is to balance the arguments. I need to take the inference in the light most favorable to the state. If I look at all of these statements, if I look at all of this evidence, in that, under that, that purview, I cannot say that reasonable jurors might disagree as to whether he's guilty or not of all those charges. And that includes the conduct after the fact. So it's the jury that's going to have to weigh what was his subjective intent and what evidence they, will see, and they will make the call. So that's going to be my finding.
Okay, Your Honor. So after the defense puts on its case, we would like to renew our
Okay. All righty. Does your client need a break before you start? Or did you want to do your 3 witnesses?
Yeah, he does. And I could use just a couple minutes checking with the first witness.
That's fine. Let's go ahead and take a 15-minute recess and come back.
Defense calls Judicial Services Trooper Young.
Okay?
Do you solemnly swear or affirm that the testimony you will give in the case now before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. And for the record, would you please state your full name and spell first and last?
David Young, David Young.
Thank you.
Go ahead, sir.
Trooper Young, good morning.
Morning.
Were you on duty the morning of December 16th?
Yes.
That's a Monday, a week ago yesterday.
Yes.
Do you recall what was going on in this trial that morning?
I believe we were downstairs looking at the trailer.
The trailer view in the Sully Port.
Mm-hmm.
After the jury departed, Mr. Renfro and the rest of us left the Sully Port, right?
Yes.
Okay. Before Mr. Renfro got back upstairs to continue the trial, did he ask you for something?
Yes, he asked for a
Objection
tissue.
hearsay, unless we have an offer of proof on this.
It's not, this is the man, this is not hearsay.
No, it's a statement by the
Your
defendant,
client,
so they
yeah.
can't get it.
All right, so, he's the defendant.
No, I know, but it doesn't say, it doesn't make it not hearsay, it's an out-of-court statement. It's gotta
Depends
fall
on the
within-
nature of it.
I'm laying a foundation,
Okay.
Well, right,
and this
but
will
he-
take 1 minute before we're
Well,
done.
the problem is, he asked for the statement, and now he's saying he's laying the foundation. That's not the way it works. You gotta lay the foundation first to establish.
I concur, you gotta lay the
But
foundation.
that is the foundation, Your Honor. What else, did the defendant ask you for something,
Well,
an
then-
object?
We can approach the bench, and the foundation can be laid at the bench.
You can proceed, then. I'll let the rest of the-
Did Mr. Renfro ask you for something?
Yes, he requested a tissue.
A tissue? And did you discover why he asked for a tissue?
He said he had a bloody nose.
And did he give you the tissue?
Well, I gave him the tissue, but I didn't witness any blood.
Did you, not on the tissue?
No, not on, like, his clothing. He had
No,
white.
no, just on the tissue.
No,
Did he give you the tissue back?
no.
Okay, thank you.
Any cross-examination?
Can I have a second?
Sure.
Not that I can think of at this point.
Okay, you can step down, sir.
Your Honor, the state calls Shara Renfro.
Defense. Come on up, ma'am.
I take that back. The defense calls Shara Renfro as the next witness.
Do you solemnly swear or affirm that the testimony you will give in the case now before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. And for the record, would you please state your full name and spell first and last?
Shara Renfro, Chara Renfro.
Thank you.
All right, sir, you may begin.
Ms. Renfro, you share the same last name as Bradley. What's your relationship with Bradley?
I'm his stepmom.
And when did Bradley first come into your life? How old was he?
He was just over 2 years the first time we met.
Okay. And you lived in the same geographical vicinity as his mother?
I lived in Wasilla. He and his mom lived in Anchorage.
All right. And what was the civil custody arrangement between the parents at that time, the birth parents?
My husband had 2 weekends out of every 3.
And he exercised those rights
Yes.
regularly? And was there a change in the custody agreement at some point?
Yes, when Bradley was about 9.
And how did that custody arrangement change?
He came to live with us.
Okay, same arrangement?
Same
where-
arrangement, just,
Flip-flop.
yeah, flip-flop.
And And then, for how long was Bradley living under that arrangement at his father's house with you?
I believe it was until about the end of 2014.
So close to the end of the year of 2014.
Yes.
Leading up to that time, was there a point where you had concerns for yourself about remaining in the home leading up to Bradley's, the end of 14?
Not prior, well, yes, I guess it was a little prior to that time. I think that fall, I just started feeling like I needed, honestly, I needed a sober home in order to take care of myself.
And who was, at that time, who was Bradley's primary caretaker?
I was.
And when you felt that need for your own well-being, you needed to be in a sober home, why didn't you just make that separation then?
I have no legal right to Bradley, and I couldn't leave him behind.
What? And did you, in the end, separate for a period of time?
I did. May of 2015, I moved out to my own apartment.
So, timetable-wise, in the fall, you felt you needed to, for yourself, to be in a sober home, but you didn't want to leave Bradley behind. But once he moved out at around the end of the year too, right? Is that what you're saying?
Yes.
You stayed a little bit longer, but then you made your separation.
Yes.
And Bradley, all right, I've got one more question. During those, let's see, 9, 14, 5 years or so, did you observe Bradley to have spontaneous nosebleeds, and if so, what frequency?
Not very frequent. He did have them, well, all I can say is he had them more often than I did when I was a kid, but it wasn't often.
Once a year, once every other year, or like approximately how many times in that 5-year period? Or even on the weekends since 2 years old over that entire 12 years? If generally, just ballpark that you can recall.
I probably 1 or 2 times a year.
That's all I have, thank you.
Thank you.
Oh, no, cross-examination. Go ahead, Mr. Gallatin.
I'll have to backtrack a little bit here to get a better idea. You were married to Russell Renfro,
Yes.
and when did your relationship with him start?
Either October or November of 2002.
And when did you get married to him?
June 14th, 2003.
with him continuously between 2003 and when you moved out?
Yes.
So 2003 till May of 2004?
Yes.
14 rather? And what was the reason for you moving out again?
In a nutshell, I needed a sober home to take care of myself.
Okay, and was Russell Renfro physically abusive too?
No.
Did he have temper?
Not particularly.
Not particularly? On occasion?
When he was not sober.
And you're saying that that was most of the time, that he was not sober, that was the reason why you left, right?
No, there were times when he was sober.
Okay, but,
He was sober when we got married.
okay, right, I get that, but then we're talking 11 years of living together, so it just got, what, every year it got worse?
No, there were periods of sobriety.
And, the defendant, Bradley Renfro, he lived continuously with you from a certain time period till when you moved out?
To before when I moved out, yes.
Okay, so give me that time period again. When did he start living with you in your house?
He was 9, he was in 3rd grade. And then I believe he moved out.
You moved out, right?
He moved out first,
He moved out first.
yes.
Okay, when did he move out?
About the end of the year 2014.
What was the reason for him moving out?
My husband decided it was time for him to move back to his mom's.
For a particular reason or not?
Objection. Can we approach the bench?
Jerry's been excused. I'll Mr. Galicek explore this a little bit, and I'll determine what questions can be answered.
So, and it still is Mrs. Renfro?
Yes, it is.
Right. So you're still married?
I am.
Okay. Does that mean you're back? You live in back?
Yes.
Okay, I suppose we should cover that, because that was left in a different light with the jury. But what I was gonna, my question was, why did Bradley Renfro leave before you did in 2014?
He and my husband were butting heads a little bit. Well, he and I were too a little bit, just, you know, testing the boundaries, normal teenage stuff.
Was it over rules in the house?
No, I don't think it was. Just,
Okay, I'm sensing you're being very guarded as far as your answers. What was it about? The jury's not here. What was it about? I don't know why you're being apprehensive.
because that's my nature.
Okay.
Specifically, the straw that broke the camel's back was Bradley said something disrespectful to me. I don't remember what it was at the time. It wasn't anything grand. But as you pointed out, my husband is a little short-tempered when he's not sober most of the time, and that was just it.
Okay. I think that's a fair enough
Yeah.
answer that she can give. If that's the extent we explore. I mean, that seems the reason why he left. Are either of the parties gonna ask how long he stayed away or where he went or anything?
Well, unless she has personal knowledge about that.
So, we'll let you answer that question, ma'am, but I'd leave it at that, Mr. Kalicek.
Okay.
All right, we can bring the jury back in.
Can I do a redirect?
At this point?
Yes.
Yeah, go ahead. I mean, is there,
While the jury's not here,
is it about this question or?
I'm not sure what, I
Yeah.
don't think there is a redirect, we're just doing I'm trying, the defense knows.
I can save it for the jury, that's fine. I can do it now, or I can save it for the
Well,
jury.
if it calls for hearsay or anything.
Or if it opens any doors, I mean,
No,
that's,
you can see what I'm doing.
okay,
Actually, the
Try not
state
to.
does not see, I mean.
No, about opening doors.
okay. All right, so we can bring the jury back in and I'll let you ask, limited to that question, and we already know what her answer's gonna be, so that's clearly admissible, so bring him back in. Okay, please be seated, and we're still on record, so go ahead, Mr. Kalicek, to get the question.
Mrs. Renfro, we were talking about your departure from the household in 2014. Again, which month was that?
I left in May of 2015.
May of 2015. And I think you were saying that Bradley Renfro left earlier, is that right?
Yes,
And this is a house in Wasilla, Alaska?
yes,
owned by Russell Renfro?
We own jointly.
And when did Bradley Renfro leave?
I believe it was the end of the year 2015. I'm sorry, 14.
Okay. And when you say, and I think you were trying to explain, it didn't mean he just left to be out in the world. It meant he was going back to his mother's house, right?
Yes.
And that's Brittany Smith?
Yes.
Okay. And did she live in Anchorage at that point?
I believe so, yes.
All right. And I think I was asking you the reason why he was leaving. Why was he going back to Brittany Smith's house?
He'd been butting heads with us a little bit, just he said something disrespectful to me. It wasn't anything really terrible, it's just my husband is a little short-tempered when he's not sober, and that was just it. He said, okay, you're going to your mom's.
And was there, on the part of Bradley Renfro, did he also get agitated? Was there an argument between him and his
Objection.
father?
What's the objection?
It's going beyond what is, it's not really relevant to what happened when he turned 14, or when it was a flip-flop in custody, basically, and we heard that it was normal juvenile.
I'll sustain the objection.
So just butting heads in general, right, between you and Russell and his son, right? And
Yes.
then he decides to send his son back to his ex-wife, right?
His ex-girlfriend, yes.
Okay. And he was 14 at the time, right?
Yes.
And the butting heads, was that just on that day, or was it a progressive thing?
Objection, same thing.
Well,
This is a fishing expedition.
Well, I'm not sure why they called the
It's
witness.
not relevant
Okay.
to.
Well, their own experts said that parenting
I'm gonna
is
sustain the
important.
objection, Mr. Kalachek. It's beyond the scope, so.
Do you feel like you had a hand in raising Bradley Renfro between the ages of 9 and 14?
Yes.
You seem like a pretty mild-mannered person to me. Am I reading you correctly?
Yes.
Okay. Are you a law-abiding person?
Yes.
Did you teach Bradley Renfro the difference between right and wrong?
Yes.
Did you teach him the difference between a truth and a lie?
Yes.
Did you teach him the value of human life?
I don't know that I had to teach him that specifically. That was always been understood.
You sat did you sit throughout the whole trial here, and
Yes.
these photos?
Objection. It's beyond the scope of direct, way beyond at this point.
It is, Mr. Kalachek. And she testified to very limited testimony, so it's beyond the scope.
Well, I was gonna ask him, was she aware of any of the associations that we see in 2016, back when he was under her roof?
I still think it's beyond the scope, so.
Well, I'm trying to figure out what was the scope of
Is
the defense.
this needs to be clarified. Is this when she lived at the house?
Right, right.
When he lived.
Personal knowledge, I mean, whether this witness had personal knowledge of his associations and this gang emulation at that point.
Again, I don't think the record indicates anything from 2014.
Well, we don't know because I never talked, I mean, she's a witness called by the defense.
So this offense was 2 years later from the time period we're talking about.
Well, according to their expert, a person develops.
Okay, Mr. Kalachek, we're beyond the scope, so I'm gonna grant the objection.
What was your position on alcohol and marijuana use by underage people in your household when he lived with you?
Absolutely not.
Same objection. This is 2 years before this event occurred.
I
It's
think
just
it
more of
was-
the same, Your Honor. He's not.
Okay, Judge, we just had a whole dissertation on maturation of human
Okay,
beings.
but she's not the witness for that, Mr.
She
Kalachek.
isn't.
He
Judge,
called, Mr. Kalachek, he called the witness, he did
Right.
limited examination. It was primarily to when he left the house, and it was to something to do with his bloody noses.
Well,
which-
I understand.
And that was it. So that doesn't open the door for a whole history of his childhood with this witness. It just
He got
doesn't.
into the witness that the defendant lived with her between ages 9 and 14. Are
Okay.
we saying that we should ignore Dr. Smith's testimony that people are maturing?
Mr. Kalachek, I'm gonna strike that comment. This is not about Dr. Smith. This is about a limited testimony by the stepmother. Let's leave it at that.
Okay, so here's my question, Judge. What's the relevance of her testimony?
That's a fair question.
So it's not for, no, I'm
Just let him answer it. That's a fair
Well, but
question.
I wanna just
Well,
explain.
let me,
I wanna
What was
explain
the
myself,
relevance?
Judge,
What's your
because
question?
we're exploring what we should be doing here, like what can the state ask?
Mr. Kalachek, you raised an issue of relevance. You didn't raise it while he was asking the question, so
Right.
I'll let him answer it now. What was the relevance of your limited direct testimony?
The relevance is his placement history, not his entire psychosocial history. Who did he live with as a child? Change of custody between a civil custody agreement with parents, where mom raised him till he was 9, and it was time to switch it over and let dad step up
And how is that
And-
relevant?
well, and the bloody nose.
Well, bloody nose is a separate thing. Maybe you can explain the relevance of that, because there's an objection to that testimony.
Oh, well, look, Your Honor, we are putting on a defense. We are corroborating, step by step, piece by piece.
So what you're saying is the relevance will occur down the road with your next
Absolutely.
witness or something. That's fine. You can make that statement. But as far as his history as a child, I don't think it has any relevance at this point. And if it does, then the state can ask questions on follow-up of it. I mean,
But this is,
it's.
Your Honor, I'm asking the court to apply the simple rule
I did.
that
So,
cross does not go beyond direct.
well,
I have very limited purposes, and it'll come out more later. This is corroboration. This is the defense's opportunity to build the defense to corroborate what we claim to be his defense.
So Judge, he's establishing placement with adults, but I can't ask any questions regarding the details of those placements. Is that where we're sitting right now?
Not psychosocial, we already have an order in that regard.
Do we? I mean, we have an order saying that.
Okay. Here's the situation. I'm not going to take the jury down a road where we litigate the entire custody that he had. There's simple facts that are in place. We know that he left his father's home in 2015. That's been now established through this witness. And he left because he had an issue with his father. That's already been put on the record earlier through
Exactly.
Misty or somebody
There's
that he
that
left.
nexus of,
But, you know, the dynamics between him and his mother in Anchorage, or him and his father beyond the fact that he just left, I'm not gonna litigate that whole thing at this point. It's,
But what the state's saying is it's either relevant or irrelevant. Just skimming over the history does not provide
all right, here,
any
Okay.
guidance.
there's
to
all
anybody.
kinds of relevant, besides corroborating what we have to put in the record. Now, Alana Peterson is the one who said his father was a mean alcoholic.
correct.
This just corroborates from his wife that fact and evidence, no more than that.
And the
But
rel-
I have other reasons that will come clear, that he has a right to put on a defense. And there's nothing that compels us to tell the state.
here's what I'm gonna do. I'm gonna limit the testimony and the questioning of this witness at this point in time. She's gonna have to remain under subpoena. If there's a rebuttal situation, if something comes up where his entire childhood is put at play, then you can call her back.
But I need to understand, Judge, what is the court limiting the state to in cross-examination? A witness is called by the defense. He thinks that she's relevant. I don't understand how the placement is necessarily relevant to the issues in this case.
Well,
I'm limited in exploring the
I
issues.
think the issue is where was he living and limiting it at that. Why he wasn't living there, I don't think that that's the issue at this
I mean,
point, so.
if those are the ground rules, like where he was at given times, I could work with that at this point. So you're saying, let's go beyond that. You're saying he left in May, in end of 2014?
Yes,
And did you remain in the house until May of 2015?
yes.
And did he ever come back during that time period for any reason?
I do not remember if he came to visit on a weekend or something, but that's all it would have been.
So maybe he came back and visited with you and your husband?
It's possible.
And how long did you stay away after you left in May of 2015?
2 years?
So are you living with Mr. Renfro again now?
Yes.
And when did you start living with him again?
June of 2017.
And when Bradley Renfro lived with you and Russell Renfro, were there any other children in the home?
He does have an older half-brother through my husband. He was not living there at the time. He may have come and visited. I don't remember.
But you're saying during all those years, from when the defendant was 9 to 14, there were no other children in the house, living in the house?
No.
No. So in terms of parenting, he was the sole focus of your attention, your husband's attention?
Yes.
Thank you.
Any redirect?
No redirect.
All right, thank you, ma'am.
Oh, Your Honor, I'm sorry. Of course. During that period of time, just a moment, please. Ms. Renfro, before you moved out, in fact, more relevantly, before Bradley moved out, or possibly even after you moved out, if you were providing transportation, who was Bradley's best friend?
His name was Chris McAllister.
And what was his mother's name?
Pamela, I believe her last name at that time was Height, but is Grundon now.
Pamela Hyde. And were you involved with, did Christopher come to your house to visit?
Yes, he would come spend some weekends with us, and Bradley would go spend some weekends at their house.
Were you involved with transporting her?
Yes.
Approximately where did she live?
She used to live just down the road from us, and then she moved to Meadow Lakes.
Is that near that what's that gas station, Meadow Lakes?
I believe it's a Holiday on the corner of the parks there.
And what's Parks and side, do you remember the side street?
I don't.
But it's a Holiday on the Parks at Meadow Lakes
Yes.
Division. All right, thank you.
This is new, it wasn't covered in my
Go right in,
cross.
go right in.
When was Chris McAllister his best friend, what year?
I don't remember which year they met, but it was during elementary school and onward.
You don't remember which years in general?
I don't.
How many times had you seen this Chris McAllister?
Fairly often, when he lived in the same neighborhood, he would come over after school.
You don't remember the years?
I don't. It would have been 3rd grade through 6th, at least.
3rd through 6th. And you did not have, did you have contact with Bradley Renfro in 2016?
Intermittently, yes.
Just by what, him coming over to the house or what?
At that time, I was still in the apartment. He would call me every once in a while. He did come over a few afternoons just to take a shower and sit and watch TV.
Did you know who his friends were in?
Objection is beyond the scope of.
Well,
No,
direct
No,
I'll let her
because
answer.
it's
She
whether-
can- She can answer this.
Right.
so.
State can call her back, Your Honor said, when she'll stay under subpoena.
No.
He's on the stand talking about the exact stuff that Mr. Provost just asked her about 2 minutes ago.
If she wants to answer questions on friendships, that's fair enough. Go ahead.
Mr. Provost raised the issue of Mr. McAllister. Do you know whether he was friends with Bradley Renfro in 2016?
I know they weren't hanging out together anymore.
And how many times do you figure you saw Bradley Renfro in 2016?
Maybe 2 or 3.
And you're saying this Christopher McAllister's mother's name was what?
Pamela Height at the time. I believe it's Grundon now.
Thank you.
Okay. Thank you, ma'am. You can step down.
So, just a little redirect, Your Honor, please. Just a
Oh,
question.
okay.
Ms. Renfro, about your testimony, 2016, had you returned to your husband at that point in time?
No.
All right. And during that time, Bradley would call and stay in touch and maybe stayed with you, you say 2 or 3 times in 2016?
Yes.
So is your testimony that you just didn't see Christopher coming over? Or, I mean, how would you know what kind of relationship he was having amongst his friends if he wasn't living with you?
I suppose that's true. I don't remember him talking about Chris.
All right, thank you.
All right. Thank you, ma'am.
Could we have 10 minutes before we call our next witness?
Okay. Let's take our afternoon break. 11 o'clock, 10 minutes.
The defense calls Brittany Smith.
Do you solemnly swear or affirm that the testimony you will give in the case now before this court will be the truth, the whole truth, and nothing but the truth? I do. Thank you. You may be seated. And for the record, would you please state your full name and spell first and last?
Brittany Lee Smith, Brittney Smith.
Thank you.
Okay, go ahead, sir.
Ms. Smith, what is your relationship with Bradley?
He's my son.
So I'm going to ask you just a few questions to bring the timetable further up. Do you remember well, just a little foundation. How old was Bradley when you and his father separated?
A little over a year old, or a little under a year old, I'm sorry.
And what was the custody arrangement?
Once we were done with court, it was sole physical custody for me and joint physical custody for both of us.
Did you have an amicable arrangement for sharing some visitation with the father?
Once that was established with the court, yes.
What did that look like?
He visited him 2 out of 3 weekends and optional to visit on a midday in the week on a Wednesday.
How'd that go?
Well, since he lived in Wasilla, he didn't visit it during the week very much. And weekends, 2 out of 3 weekends, most of the time he visited with him.
And do you remember the month and date when that custody arrangement changed?
September of 2014. 2009.
Okay, and at that point, was there a change in the custody arrangement?
Not through the courts.
So what did you and his father work out?
Basically, we would just switch the arrangement, let him live with him and visit me 2 out of 3 weekends.
And you was how old at that time?
9.
Okay. And that went on for how long, that arrangement?
Until he kicked him out in November of 2014.
So November of 2014, he comes back into your custody, right?
Yes.
And how did that, was there any discussion of switching back to a different rotation?
No.
How did he come back into your physical custody then?
He was dropped off at my work with a black bag in his hand and handed me a note from his father and said, "I can't live there anymore."
Did you have any notice of this?
No. Bradley walks into my office crying, and nothing I could do but take him back.
So what was your living situation at the time?
I was living with my boyfriend at the time, who's my ex now.
And what was the housing arrangement?
Well, it wasn't my house. I was paying rent to him. It wasn't, with my situation, I just wasn't allowed to let Bradley live there.
Why is that?
Well, because
Did he have kids?
he did not have kids. He didn't want kids. He didn't prefer kids. He would allow Bradley to come visit, but he wouldn't allow him to live there.
So you would have had to leave him and find your own place.
Yes. And I wasn't prepared to do that financially.
So as his mother, what placement did you feel would be suitable for him under your circumstances at the time?
I asked my older son if he would take him in, and he agreed.
Okay. And so from November of 14, you placed him with his older brother.
Yes.
Where did he live?
In Mountain View, Anchorage,
And you lived in?
West Anchorage.
And did you keep regular contact with Bradley during that period of time?
Oh yes, every day.
What kind of contact was that? It was every day?
My older son would bring him to work in the morning, and I would take Bradley to the bus stop. make sure he got to school, picked him up from school. He would hang out with me until the workday was over, and then he would go home with my son for the day.
So sounds like you spent a lot of time every day. You just couldn't he couldn't live there or spend the night at your house.
Correct.
Or your partner's house. And how long? How long did he live with your oldest son? Because he was in school at this time, right? Where was he in school?
Romig.
How long did that arrangement last through the school year?
Yes.
And then what happened then?
During the summer, Bradley was hanging out with his friends, and he didn't get along with Alan. He felt like Alan was treating him like a slave, making him do all the chores, and so he, would hang out with his friends for most of the summer.
Did you know of that dynamic?
Yes.
Was that a pretty accurate description of the living arrangement with?
Yes.
And did you know the friends that he was staying with in the summer?
Yes. I would drop him off and pick him up from hanging out with his friends daily.
Was Christopher one of his friends?
Christopher was one of his friends early on, before all this. This was after Bradley moved back to his dad's after 2009. When he was coming to my house to visit, Christopher would come to stay the weekends with us sometimes.
But at the summer of 2014, you didn't see Christopher?
No.
Okay. What was so what were you planning to do for the fall for school?
Since they were still butting heads, and I want to make sure Bradley had a safe place to be, I offered to have him go down to Washington to live with my mother for the school year.
And how did that go? Or what was he getting signed up for school and preparing for school down there?
Yes, he started football. We had registered him. He was working really hard to do the football thing.
Did you end up following up in that placement with school after all?
He did not. I'm going to say he missed his friends, he missed his family up here. He wanted to come back. I really wanted him to stay down there, but his father brought him back up here.
Do you know what led to, do you know at the time what led to his moving back to Alaska? What was going on with he and your mother?
He
I would object unless this is from personal knowledge, not from information gained.
You have to lay a better foundation.
If she observed.
Yeah, well, you don't have to say what your mother said or anything, but, so you testified that he was on the football team. Did you stay in touch with Bradley while he was down there?
every day.
Every day. And checked in with his grandmother, how things were going.
Yes.
And at that point, did you have any concerns?
No.
Was there something in particular besides being lonely for Alaska?
He was depressed.
Well, same objection, Judge. Now we're getting into hearsay, what the defendant told her. She wasn't in Washington.
I'll sustain that.
Relevance to any of the issues in the case.
And I don't think it's relevant at this point.
All right.
It's already established he wanted to come home.
All right, so
Beyond that, it's.
we're there then, because I want to place him back in Alaska. So, when you came back to Alaska, Were you involved with that decision?
No.
And when he came back to Alaska, where was his placement?
He lived with his father.
And that would have been in what month and year?
September of 2015.
And the final question, there's been some evidence that Bradley had, you can decide frequency or how frequent or not, but we've heard testimony maybe a couple of times a year. Did he ever have, did you know him to have those kinds of occasional nosebleeds?
Yes.
From what age did you first see him?
I'm gonna say probably around the age of 5.
And how often?
I don't know, 5 to 7 times a year.
Did you ever investigate what was causing or triggering nosebleeds from a health perspective?
Yes. Took him to see an ear, nose, and throat doctor. He ended up having his tonsils and adenoids removed.
Did he continue to have nosebleeds after that?
Yes.
Did you seek medical consultation, try and figure out what else there could be going on?
No.
Okay, thank you.
Go ahead, Mr. Counselor.
I wasn't able to write down the whole timeline, so I might have to re-ask some of the questions about the exact dates. So this goes back to the switch in arrangement. Back in what year when he was supposed to come back to you in Anchorage?
Say that one more time.
When he was supposed to come back to you, there was a switch in the custody arrangement.
He wasn't gonna come back to me. I had him from birth to 9 years. At 9 years, I switched custody with Russ. He was supposed to basically, grow up with Russ as a father figure, needing the male influence.
And what year was that he went back to his father?
2009,
2009, and then when did he get kicked out of his father's place?
2014,
So he lived with his father continuously
for 5 years.
for 5 years. And that's when his father was married,
Yes,
remarried, right?
I-
Shara was her name?
yes,
Okay. And did you know her or not?
yes,
But nonetheless, he stayed there from 2009 to 2014, right?
yes,
Then he got kicked out in 2014.
yes.
And you knew he was butting heads with his father, right?
Not really, no.
Okay. You didn't really know about any of that? All right. How about, okay, so he's supposed to go back to your place, right?
Well, he wasn't supposed to. He got dropped off at my work.
Right. And you're in
And,
Anchorage?
and I had no clue that he was being dropped off. I had no clue there was issues.
And you're living with your boyfriend?
Yes,
And why does your boyfriend doesn't want to be a father, or he
no.
butts heads with Bradley, or what's the story on that?
And just, he's not a kid person, and it wasn't my house to bring him into.
Right. So I suppose you had the option of moving out,
I
like ceasing
did,
your
I
relationship?
did if I was financially stable.
Right, I understood what you said. There was financial impediments to you getting your own place in Anchorage?
Yes,
All right, so that's when you sent him to your parents,
to my sons,
to your son first,
yes,
and that's Alan,
Alan.
and he lives in Anchorage.
Yes.
How old was he at the time?
He was 21, I think.
And this was in 2014 still, or are we into 15 now?
The end of 2014,
No.
he would have been 21.
All right, now, in an interview, he specifically said he did not, quote, did not like being his brother's bitch, right? You were there when he said it.
Objection. We had this conference.
Well, no, this is
It's beyond
about,
the scope of direct.
Okay, you're talking about Bradley, didn't you?
she already said that he.
What we were talking, this,
Okay,
No,
I'll let him do a little bit.
Right,
You
she-
talked
she-
about him butting heads with his brother. You can
She-
explore
she-
this a little bit.
She
so go
testified
ahead.
on direct that he butted heads with his brother, and that's the reason he moved out.
Okay, go ahead, you can answer the
He
question.
specifically told you he did not like being his brother's bitch, right?
Basically, yes.
Okay.
He felt like he was a slave, having to do all the chores.
All right, so he was the one that elected to move out of his brother's house.
It was a mutual agreement,
And how old was he then?
14.
And what happens next?
Yeah, 14.
What happens next?
They continued to live together for a little bit, and then, like I said, throughout the summer of 2015, he was hanging out with some friends and whatnot, and when it was getting,
Yeah, I'm gonna back up a little bit. So, summer of 2015, he was flying solo.
not necessarily.
Well, as a parent, when you say the whole summer he was hanging out with friends, what exactly does that mean?
Not the whole summer, throughout the summer,
Okay, where was he living during that time period?
with Alan, and he would stay with his friends on
Okay.
weekends or
Let me narrow it down. You said he left Alan's house. What month did he leave Alan's house?
I can't tell you that, I don't remember.
Okay, but when he left Alan's house, he was just strictly hanging out with his friends the whole time, right?
No,
Where was he living?
he didn't live anywhere. He kept his stuff at Alan's house, but like I said, he stayed with his friends.
Well, that's what I mean. He wasn't living at Alan's because he didn't want to live at Alan's. And then he was just staying with friends, right?
Or me on the weekends,
And this was summer of 2015?
yes.
And did he complete the school before that summer or not?
Yes.
At Romig?
Yes,
All right. And then remind me, the fall, I know Mr. Provost asked you what happened in the fall
in
of
August.
2015?
August of 2015, school was getting ready to start, and I wanted to make sure he had a place to live for the school year.
Okay.
So I took him down to Washington.
All right. Now, I understand your testimony to mean that you kept in touch with your son throughout, right?
Yes, I
Okay.
always have.
And do you figure that you had a hand in raising your son?
Yes,
Okay. Did you teach him anything?
yes,
Difference between right and wrong?
yes,
Difference between the truth and a lie?
yes,
Value of human life?
yes,
How to treat other people?
yes.
In other words, what I'm getting at is because he moved around, does it mean that he didn't have any positive adult role models?
He did,
Like, you were a positive role model?
yes,
Your ex-husband's wife was a positive role model, right?
my ex-boyfriend's wife, yes.
I'm sorry, yeah, I didn't delve too deeply into, but his father's new wife or wife was a positive role model.
Yes,
His father might not have been the best role model, is what you're saying?
no,
Okay. And that's because of the drinking?
yes,
Okay. But certainly, nobody condoned violence, even your ex-boyfriend didn't condone violence, right?
absolutely not.
Okay. Your parents, are they honorable people?
Yes,
And you felt secure enough to entrust your son with your parents, right?
yes.
How old were they when he went to them in the fall of 2015?
It was just my mother and, 63.
And you already said you kept in touch with your mother when he was down in Washington, right?
Yes,
Now, had he been there before?
yes,
Did he know his grandmother?
yes.
Now, the reason you sent him down there, was it strictly to provide housing for him, or was it also to give him a different environment?
A different environment also.
Because of what, you were concerned about other things?
I just didn't want him to have to deal with his father, with, you know, having to move around anymore, with, just, you know, have a steady home.
So you considered your mother to be a good role model, right?
Yes,
Is she a law-abiding person?
she was.
Okay. She have morals?
Yes,
Has she passed away since?
yes.
Was there an extended family there? Was there anybody that lived in the area?
My father and stepmother.
And they had contact with your son while they were there too?
Yes,
And do you consider your father to be a good person,
yes,
a moral person,
yes,
law-abiding person?
yes,
Did you consider him to be a positive influence?
yes.
I assume he had some contact with Bradley Renfro.
For the short time Bradley was down there, he had some contact with him.
And when you say short time, exactly how long was he down in Washington?
About a month.
And did you think everything was going well down there for the most part?
For the most part, yes.
Did you visit him, or was it because it was such a short period of time you didn't feel?
I was down there for 2 weeks of the month that he was down there
And
to get him, to make sure he was settled and had everything he needed for the school year, for, you know, football, for his physicals, classes.
And how did you find out that he came back to Alaska?
Well, he asked me if he could come back, and I told him that wouldn't have been a good idea. And he asked his father to bring him back up, and I had to agree.
So this is what I'm getting at, you know, choices. He decided to leave Alan's house, correct?
Like I said, it was a mutual thing.
Yeah, he didn't like being there.
He didn't feel like he needed to be Alan's bitch.
Right. And he wanted to come back from Alaska. He didn't want to be in Washington anymore either, right?
Right.
And he kind of used his dad. That was the, instead of going to you, he went to his dad, kind of went around you,
Yes.
did the end run. And then what, did you have no say in it? It just happened? Or what, his dad bought him a ticket? Or how did that go down?
Like I said, Bradley asked me if he could come back, and I told him that wouldn't be a good idea. And he said that he needed my blessing for me to come back, but he was depressed, and
Did you give your blessing? Did you give in?
I gave in.
All right. So when did he get back? Remind me. Like I said, I wasn't have time to write down all the dates.
September of 2015.
Now, we're still a year before the events in this case, right?
Yes.
Okay, but we're closer, so I want to be a little bit more careful about my questions about 2015. So when he came back, where did he come back to?
To Wasilla, to his dad's.
And who was living in Mr. Renfro's home at that point?
I do not know. I'm assuming Russ. But I don't know if Charlotte was there or not.
Okay. You didn't ask or inquire
did
about
not.
any of that, so you came back. And now, I assume you continued to have contact with him after you got back, right?
After a while, yes.
What do you mean?
Like I said, I was a little upset that he came back. I wanted him to have a more steady environment. So it took me a little bit to have a little bit of contact with
Okay,
him.
now, we know it's still a school.
Objection, Your Honor. We're in Alaska now. That was the scope of direct. That was the understanding.
No,
That was
I
not-
think he can ask how much contact
Yeah.
she had that year, that's fair. Go ahead.
Well,
Once-
we're getting into the placement, it needs to get up to
2015.
2016. We're not, we can't just artificially end.
I gave you permission to ask the question.
Thank you, that
Go
was
ahead.
the, right.
We probably had a couple of months cooling off period as far as, like I said, me being upset for him coming back. Other than that, I made sure he had a phone to, you know, make sure I could have contact with him, and he could call me anytime he needed to.
Right. And despite you not being fond of his father, Like, you didn't feel it was a situation where you had to call like OCS or any kind of authorities,
No.
correct? Okay. And because it was a school year, was he enrolled in school in the fall of 2015?
I believe he was.
Or did you
Well-
track it?
I did not.
So when did you start having contact with him?
I can't remember.
November of 2015?
Maybe sooner.
And what type of contact did you have?
Like I said, I made sure he had a phone, so he would call me whenever, usually daily. As far as visiting, he would come see me on weekends.
And so we
Holidays.
understand this correctly, you were still living in Anchorage?
Yes.
With your boyfriend?
Yes,
And he's living in Wasilla with his father?
yes.
But you see him about how often?
Weekends, I saw him maybe a couple weekends out of the month, or holidays.
And did you have a full-time job at this time, like working 5 days a week?
Yes,
Okay, I just want to make sure we have the full picture here. And did his father have a full-time job?
I do not know his work history.
So now that takes us to, let's go to the beginning of 2016. Is he still living with Russell Renfro in 2016?
Yes,
In Wasilla?
yes,
Going to school?
as far as I know,
So you were relying on Mr. Renfro to make sure he was going to school?
yes.
But you talked to your son, like on the weekends and on the phone. Did it sound like he was going to school?
Yes.
Um, Okay, so keep going. Is he with his father throughout 2016? That
As
you
far as I
of?
know,
Did it ever come to your attention that he left his father's house in 2016?
no.
Because you talked about the previous summer where you were just out and about with his friends, right?
But I knew his whereabouts.
Right. I mean, did you know whether 2016 was a repeat of summer of
I
2015?
do not know that.
So how much contact did you have with him in 2016?
As long as he had his phone, I'd check in every couple days, or he'd check in every couple days. I think it would be a week at the most that we wouldn't talk.
Okay. Now, we talked a little bit about these values that you tried to instill in your son. What was your position as a mother on the use of alcohol, marijuana, and any other controlled substances?
Objection?
And what's the purpose? Come on up.
what I was getting at is, what type of things did you, during this, you said you had contact with your son throughout. And my questions relate to what type of values and rules were you instilling in your son during the course of your motherhood? So that's why I asked, what was your position on alcohol and drugs? My second question is going to be, did you communicate that position to your son during the numerous contacts you had with him throughout his lifetime?
Yes, basically, I instilled a lot of values in him. I mean, be honest, be nice, you know, stay in school, don't do drugs. I mean, I don't know what you mean.
Those are the things that I mean. I mean, to know whether he learned those kind of things from you.
Well, I would be one of his influences.
In other words, I didn't want to leave the impression that he was just being bounced back and forth without having any adult role models, positive adult role models.
I always tried to be there for him.
Now, let me finish up with 2016. So, do you know what he was doing in the summer of 2016 or not?
I do not.
Were you relying on your husband to keep track of Bradley Rumford during the summer of 2016?
You mean Russ?
Yeah.
I-
I'm sorry. Yeah, I mean, that's your husband. I'm sorry. Were you relying on Russell to keep track of your son since he was living with him?
Yes.
But did you continue to see him during the summer? Would he come to Anchorage on occasion?
On occasion. You know, whenever he wanted to come into town to see his friends, or if he wanted to see me, or he'd come hang out for the weekend or holidays. Well, there's not many holidays in the summer, but
But you're saying you weren't being proactive about knowing exactly what he was doing in the summer?
no.
And you weren't being proactive about knowing exactly who he was hanging out with that summer, right?
No.
And then some of the names mentioned in this case, the others like Austin Barrett, have you heard his name before?
He's the only one I've met.
Did you meet him in the summer of 2016?
No, the winter.
The winter of what?
2016. November of 2016.
Before the murder?
Yes.
In Anchorage?
Yes.
At your house?
No.
So, Bradley was with him,
Yes.
and they came together to visit you?
They came to Anchorage together to visit another friend, and Bradley got a hold of me while he was in town and came and visited me, but I had met Austin in the process.
And how about the others, like Eric Almeninger,
And I did not know or meet any of those.
Dominic
kids.
Johnson,
No,
Devin Peterson?
no,
David Evans?
no.
And then the fall of 2016, which we're on now, was he enrolled in school that fall, to the best of your knowledge?
He was supposed to be, as far as I know, he was.
And that was, again, you were relying on Russell Renfro to figure that out with him?
Yes.
But, I mean, did people know that was your expectation as a mother, that his schooling continued?
Yes.
How would they know that?
Well, I got a call from Burchell one day saying that he needed, I'm assuming it's the name, he needed his father, or they asked me to let his father know that he needed to sign some paperwork. So I'm assuming he was being registered for school.
Right. And, I mean, you communicate, of course, to your son that you would like him to finish his schooling, right?
Yes,
And I'm assuming you communicated that to Russell Renfro also,
yes,
even though you couldn't be in the valley to monitor the day-to-day activities.
right.
And then, What was the frequency of your contact with Bradley Renfro, say, in October of 2016?
Just the standard. I probably didn't visit as much. It would have been winter time, so driving on those roads are kind of sketchy, but for me anyways. But I probably saw him once or twice and talked to him on the phone several times.
And he didn't have a vehicle during this time?
Bradley?
Right.
No,
He never had a vehicle?
no.
Give me a moment, as far as these choices, so like the fact that Bradley Renfro did not want to stay at Ellen's house, did not want to stay at your grandmother's house, is he a pretty strong-willed person?
Objection. You're gonna need character evidence here.
Well, eventually, the event we're going to be talking about,
I'll grant the objection. I'll sustain it.
but those were his choices, right? Leaving Washington was his desire and his choice.
Yes.
Leaving his brother's house was his desire and his choice.
Yes.
He doesn't like being told what to do.
Objection.
I'll sustain the objection.
Well, again, state's argument is that we're going to be dealing with issues of, did he make choices or was he forced into things? And I think his mother, of all people, would know his personality.
Is that an exception?
I think I already made the ruling, and it is beyond the scope, so.
Are any other questions?
Any redirect?
A little bit, Your Honor. Just a few questions, Ms. Smith. Let's see if we can get these facts straight. Was it Bradley's choice when you thought it was time to change the custody arrangement with Mr. Renfro?
No,
Was it Bradley's choice when he was dumped in your office parking lot?
no,
Was it Bradley's choice when you placed him with his older brother?
no,
Was he okay with that though, at first?
yes,
Follow up on how that ended. On cross, Mr. Kalachek, on cross, had the language of Bradley didn't like being Alan's house bitch. You know where that phrase came from?
I'm assuming from one of the interviews.
Not something, oh, I see. Not something you would use at that time.
No,
What about the, what would you, since you were seeing him frequently, if not every day, and talking to him a lot, were you aware of his complaint about how he was treated at his brother's?
yes,
Do you think he was just whining to you, or you think you know your other son too and what he's like? Was it a valid complaint?
it was a valid complaint.
So, meaning that it became an unhappy situation for him being treated that way.
Yes,
So is that a choice for him?
no,
Was it a choice to go to his grandmother's?
no, that was my choice.
And you knew he wanted to come back to Alaska?
Yes,
Was it a choice for him to call you and say, I want to come home?
it was.
So the default was back to dad.
Yes,
And just one more question. Only if you recall. When Bradley left his brothers and was staying with friends, do you know if he was, his clothes were at his brother's and he would come back and he'd go back and forth kind of thing?
yes,
Okay. Do you recall at some point after he'd been doing the back and forth thing, that he sought to have you help him live with his brother again?
yes, he did.
And what did your older son say?
He said he didn't feel like it was gonna work out.
So that's twice it didn't work out with his brother, and is that around the time you decided to, it's best to get him down to Washington?
Yes, before school started.
He didn't have a whole lot of choices, did he really?
No,
Thank you.
Okay, ma'am, you can step down. Let's take a quick recess. Go off the.
It's 12:19. Thinking out loud. I think, Your Honor, I would like to recess and spend some time with Bradley and come back in the morning.
Okay.
Judge, was 2.5 years not enough for them to figure out whether the defendant's gonna testify in his murder trial?
Well, I think he has a right to think about it as the trial has proceeded, so. And I wouldn't want to start it and stop it at 1:30 and then come back and continue it. if he is gonna testify, we should do it all in one shot, including the cross-examination. My guess is it would take a while, and I'm not gonna keep the jury late today. But my question to you is, if your client doesn't testify, then we would go get into jury instructions tomorrow so we can keep the case moving?
Yeah, we could do that.
Would you be ready to do that at that point, Mr. Kalicek? I mean, I don't wanna waste any time, we have to come back.
Judge, I can do instructions, I'll do whatever the court wants us to do to keep the case moving. I think the defense needs to propose, if they're asking for an affirmative defense that has some legal issues within it, they need to propose that set of instructions along with legal authority for those instructions.
And I agree.
It's in the works.
Okay, so what I would,
I'm
I'm just saying, I don't wanna recess tomorrow and then do a whole no other day and
Oh,
wait
yeah,
for jury
no,
instructions.
look, Your Honor, if we, if Bradley does not testify tomorrow, then I plan to come in with a written, proposed, well, a few written proposed instructions.
That's fine, that's fine. Okay, I'll call
And
it back.
the question then is, we deal with the instructions in the morning, that'll probably take a while. Do we want to do closing tomorrow as well, or wait till?
Depends on how long it takes to do instructions. If you propose them, does the state wanna do research, and come back? Or do we wanna, spend the day just us getting through those instructions? I mean, the bulk of the instructions we have, and I don't think there's any objection to the ones I've already handed out. Is that correct?
Not so much objections, but I'm going to be proposing with, as far as the mens rea, that there's always the insertion of the similar age, circumstances,
We object to that.
type of language that's already in the accomplice liability instructions. And frankly, Your Honor, again, this is the heart of the case. It is not a novel thing. I've had judges say, well, we're not going to use the word juvenile, but we use the language that you need to consider the evidence or the testimony is what it is.
All I'm asking is that you be prepared to make your arguments,
Yes.
what the legal authority is,
Yes.
then Mr. Kalicek can respond.
And have
Yes.
the exact wording, instead of talking around the issue, have the
It's-
exact wording. If counsel wants something other than the pattern
That's
instructions.
what I'm saying. I was going to bring it tomorrow.
Okay,
If we
that's
don't-
fine.
If Bradley doesn't testify.
And
we will
then
bring
we'll
it.
just determine how long it'll take to actually go through those instructions. You may want additional time to rebut them, I don't know. We'll just see what they look like. And worst case scenario, if that's the case, if he doesn't testify, we'll get the instructions done, get them completed tomorrow. You come in Thursday morning at 8:30 and you do your closings.
Well,
And that's the end of it.
The biggest legal issue may be the duress. And the way I look at it, it's kind of like,
Statutorily, it's an affirmative
No, I
defense.
know.
It's
Okay,
been
okay,
asserted.
okay, gentlemen, let's just wait
We
to
don't
get
need
in
to
front
raise
of
our
me.
voices. I'm just talking
Okay.
about the instructions, Judge. I'm not making closing argument yet. There'll be plenty of time for emotion come Thursday, but
There's a lot of instructions out there
Right.
on duress. It's
I
been
mean,
in
traditionally-
front of a lot of judges, so it's,
traditionally duress is a situation where the defendant acknowledges that he took some actions, but those actions were taken because the defendant was under duress of some type.
and that's why it's not available to first-degree murder.
Right, and here the defense seems to be, I did not participate, so, I mean, we'll see how that.
But that may not be the affirmative defense. He may only be doing a duress to the mental state, that he didn't form his, the required intent because he was under duress. That's a whole
Okay.
different
Murder
ballgame than a,
Murder one requires specific intent. That's why the history.
so does all of the accomplice liability.
Well, that's.
So, but duress is not available as an affirmative defense to first-degree murder. I think the case law is pretty clear on that.
Yeah, I agree.
Well, nonetheless, Judge,
For a long time.
we'll keep wondering tonight whether the defendant.
Well, and I would request, if you could, if you got notice of some of these available right now, or sooner than later, if you could give them as a courtesy to Mr. Kalicek, I think that's only fair.
Well,
So that would give him an opportunity
Sure,
to look at it,
this-
I mean, so we don't have to,
Judge, are we saying there's no more defense witnesses? Because if there are, let's have them today. And
Look.
I think it's all hinging, as my understanding, if his client testifies, he may call other witnesses.
I,
That's-
if I had other short witnesses, I would certainly disclose that now. I'm not trying to make it difficult for anybody. I've only referred to Mr. Renfro, and I need time to talk with him and see what he wants to do. So
It's a big decision, I got no issue with that.
that's what I've been saying. If he testifies tomorrow, if he doesn't testify tomorrow, let's get on with the instructions.
Okay, just be ready. But all I'm asking is if you have some of them ready now,
Well,
you shoot them over to Mr.
let me
Kallicek.
take care of the conversations we need to have, and I don't stop working, I'm sure Mr. Kallicek doesn't. When we're done here, most nights, all night. So as soon as I get some answers here, that's the first thing I'm gonna do is go back and work on these instructions.
Okay, all right.
So, Judges, as far as the plan, so I understand if the defendant testifies, that's gonna take up a good chunk of the day tomorrow.
That's my guess, I would expect.
If he doesn't, I would prefer, because I got a balance tonight, how much time did I put in? I've looked at the instructions already, so.
Well, you got the notice of affirmative defense, you got the packet of instructions that are ready to go.
I'm not gonna be putting the defense's instructions together for you.
No,
but I
but
looked at
you're
the-
prepared for your arguments. I mean, you know what's coming down,
Right.
so it's not, that's why we give notice. so.
Right, and, the other thing, what else was I gonna say, yeah, so if we can just go through them, it's obviously we're not gonna be arguing about the standard ones, we're gonna be arguing the particular offenses.
There's
So
not
if we
that
can
many
just-
that we're gonna
no,
argue,
if
I
we can
don't
go
think.
through them and analyze them, and there might be some changes that, honestly, last time I had Ms. Howard focus primarily on the jury instructions. I was doing closings and openings and all that. Nonetheless, I'll be ready to discuss it tomorrow, but then, Mike, what I was getting to is our closing's gonna likely be on Thursday then. Or what's tomorrow? Tomorrow is
well-
Wednesday, right?
Tomorrow, I would probably presume Thursday. I think that would give everybody, because you're not knowing if he's testifying or not, he's not knowing, I mean, that's gonna impact your closing, to prepare it tonight.
Right.
And I think to be fair with everybody, you need to know what instructions are coming in, really, to do an adequate
That
closing
helps.
argument. I mean, it does help, right?
Yeah.
So, I mean, we're fine. If we do them Thursday, we're good to go. Like I said, we got this courtroom till finish closing the evidence by Friday. We have another courtroom to use for playbacks and everything next week. So with the court system, we're fine.
So the only other question I had, Judge, Ms. Smith is potentially, Mr. Provost already said he might recall her if the defendant testifies.
Yes,
She could potentially be a state rebuttal witness.
that is true.
And I haven't put a subpoena on her, but.
Is she present? Okay, ma'am, I'm gonna ask that that you remain in Fairbanks. Depending on what happens tomorrow, you could potentially be called as a rebuttal witness. If that's what you're asking me to do?
Well, I think it's more the defense says that they might call her after the client testifies. If the client, I don't really foresee a situation if they call her after the defendant testifies. I wouldn't need to call her rebuttal because they'd be calling her and I could just cross-examine on those points. So really, it would only be a weird situation where, like, if.
But you wanted me to give her notice so she wouldn't leave.
Well, I presume I was just asking whether she's.
Well, here's the thing, I mean, whether I call Ms. Smith, if or if not Bradley, if Bradley testifies, then you get to do cross. If you're gonna call her as a rebuttal witness, I have a request on her behalf. The reason why she hasn't been here for this trial is she has to work. She had serious near-death medical issues earlier this year and just she had to work. She doesn't have the money to spend more nights here. The request on her behalf, if the state is gonna call her as a rebuttal witness, that she'd be able to testify from back home down in Anchorage, telephonically.
My question was she planning to stay just due to the defense subpoenaing her? Was she planning on staying overnight until we hear
That's a
what?
fair question.
Yeah, she'll be here till Friday morning is what she.
Oh,
Okay, so
okay.
that solves much of the problem.
Then I think we have an issue then.
Was it Friday morning?
I don't have a return ticket yet.
Okay,
Right, so I think, Judge, tomorrow morning, hopefully we'll know.
we'll know how the case proceeds. They will probably rest if he doesn't testify. If he does, they may call additional witnesses, and you may do a rebuttal case.
And when I
Either
was-
way, I think we would probably get most of it
And when I
done.
was talking rebuttal, I am talking extremely remote possibilities, not knowing whether the defendant testifies, what he's gonna say. I'm just saying if there's a teeny chance that I might need a rebuttal, but probably not.
Okay, I think that's only fair. You don't really know till their case closes, Mr. Kalichek. Okay, let's bring the jury in. We'll excuse them for the day. Have them report at 8 o'clock tomorrow. Mhm. Okay, please be seated, folks. Here's what we're going to be doing. I'm going to be recessing you for the day. Tomorrow we'll be coming back, and we're still on schedule to get the case to the jury for deliberations, hopefully by the end of day Thursday. I will tell you that, Fridays, if we only want to work a half a day, that'll be fine, as far as deliberations go, for your own schedules. But next week, normally we do deliberations a full day. And because you are deliberating, they provide you lunch, okay? Once you're seated and the evidence is closed, you'll be ordering lunch, but we will be working full days during the deliberation process, okay? It's normally not 8:30 to 1:30, okay? So you can start preparing for next week, and potentially starting Friday, we'll just see where we're at, okay? All right, so have a good afternoon, and we will see you tomorrow morning at 8 o'clock.